Good afternoon. I'm David Ferriero, the Archivist of the United States, and I'm pleased to welcome you to the William G. McGowan Theater here at the National Archives. And pleased you could join us for today's program, Constitutional Ethos, Liberal Equality for the Common Good, with a very special guest, author Alexander Tsesis. Before we get started, I want to tell you about a few other programs coming up here soon in the McGowan Theater. On Thursday, October 5th at 7, a panel of judges, lawyers, and experts will explore the legacy of the 4 women who have served on and the 726 women who have argued before the United States Supreme Court. Moderated by Amy Howe, panelists will include Judge Patricia Millett, Deanne Maynard, Sarah Harrington, and Marlene Trestman. The program is presented in partnership with the Constitutional Sources Project. And then on Friday, October 13th at noon, we present James Holland, The Allies Strike Back. In his book, Holland chronicles Germany's invasion of Russia unfolding in the East, while in the West, Americans formally entered the war. Defeat Rommel in North Africa, and the bombing of Germany escalates, aiming to destroy Nazi industry and crush civilian morale. And mark your calendars for October 17th at 7 p.m. when we'll be hosting our next Vietnam-related program. Journalist and author Cokie Roberts will moderate a discussion with Ken Burns and Lynn Novick, directors of the PBS documentary, The Vietnam War. This event is one of a series of public discussions, book lectures, films, and other programs to be presented in conjunction with our upcoming exhibit, Remembering Vietnam, which opens in the Lawrence F. O'Brien Gallery on November 10th. To learn more about these and all of our public programs and exhibitions, consult our monthly calendar of events online at archives.gov. As you know, the National Archives is the home of the Declaration of Independence, the Constitution, and the Bill of Rights, collectively known as the Charters of Freedom. It's our privilege to be able to preserve and share these founding documents that have guaranteed the rights and freedoms of Americans for over 230 years. In today's program, Constitutional Ethos pervasively demonstrates the relevance of the Declaration of Independence, the U.S. Constitution's preamble to the Constitution, and author Alexander Tsesis skillfully uses history, doctrine, and philosophical analysis to demonstrate the relevance of principle to the resolution of contemporary legal issues, from healthcare to campaign financing and public accommodation law. Reviewing the book, Stanford Levinson, the author of Framed, America's 51 Constitutions and the Crisis of Government, says, he develops this argument about America's constitutional ethos by emphasizing the importance of paying full attention to the much too ignored preamble of the Constitution. It is the preamble, after all, that establishes the point and purpose of the overall constitutional enterprise. And he consistently offers illuminating insights about the merits of fully integrating the preamble into the way we think about the Constitution. Alexander Tsesis is the Raymond and Mary Simon Chair in Constitutional Law and Professor of Law at Loyola University School of Law. He teaches constitutional law, First Amendment, civil procedure, and seminars devoted to civil rights issues and constitutional interpretation. He's a frequent presenter to law school faculties nationwide on issues involving constitutional law, free speech, and civil rights. And he's the series editor of the Cambridge University Press Studies on Civil Rights and Civil Liberties. He's been an expert witness for the Canadian Department of Justice and a legal advisor to Senator Edward Kennedy. His articles have appeared in many law reviews, including the Columbia Law Review, Cornell Law Review, Minnesota Law Review, Northwestern, and Texas Law Review. And his books include For Liberty and Equality, The Life and Times of the Declaration of Independence, We Shall Overcome, A History of the Civil Rights and the Law, the 13th Amendment and American Freedom, A Legal History and Destructive Messages, How Hate Speech Paves the Way for Harmful Social Movements. He's also the editor of Promises of Liberty, the History and Contemporary Relevance of the 13th Amendment. and the author of For Liberty and Equality, and We Shall Overcome. Ladies and gentlemen, please welcome Alexander Tsesis.
Thank you so much. It's an honor to be here, and I'm deeply grateful to the staff at the National Archives, and especially Doug Swanson, who began work on this, David Ferriero for coming today, and Susan Clifton for hosting me as well. And thank you all for coming out on this beautiful, hot afternoon. I don't know if you're here for me or just to get out of the heat, but it's good to see you. I want to take a look at documents which, of course, this institution is so critical in housing and bringing attention to. I've been here before where there's a long line out to the street with people curious about the document. But we know that what's important is not the physical manifestation of the document. Why do we have guards? The guards are not just here because of the physical parchment, but because of the principles that that parchment imparts on us as a nation. And the message also that it sends to the world, not only about who we are, but what we've stood for and what we've been able to overcome in our own national history, which has so many faults. Over the last 2.5 centuries, America's founding commitment to the preservation of inalienable rights to life, liberty, and the pursuit of happiness has influenced the development of law and culture. The Constitution set a framework for carrying out the national mission to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. The constitutional law has also provided aspirational goals and sovereign mandates, as well as just basic structural mechanisms about achieving a fair treatment for a better national community. So what I want to do today to lay out some sort of roadmap first off before launching into it is to first speak about the sources of constitutional theory, or to do a little bit of an introduction even before that, and then to speak about the theory that I have in this book, this Constitutional Ethos book, which is before you. Talk about the various competing theories to try to place the the argument within other scholars as well as judicial interpretations of the Constitution, and then finally discuss the contemporary implications of what I'm trying to do. But before I get to the contemporary and the applicability, I need to tell you about this methodology of trying to understand the Constitution, which, as I say, once I hit the theories, you'll see is unique and quite distinct from what the main trend was. But I'll also tell you a little bit of a kernel that's, I don't know how much of a secret it is, but sort of a secret of the book, which is that I was trying to get at the core principles of the Constitution and the way that they could be applied to give kind of an aha. It's always been there, right? But to say something that others had not probed, had not quite said. But for us as a people to say, this really appeals to me, whether I'm liberal or whether I'm conservative. Because to take this document and to give it only to the liberals or only to the conservatives or only to the moderates, for that matter, would be holding these documents and these doctrines hostage to the political whims of the day. So my book, Constitutional Ethos, develops an understanding of constitutional law that's built on our government's duty to set policies beneficial for individuals and the general welfare. These things are typically separated. Typically, we have sort of a liberal theory, which is not liberal in the Democratic Party sort of sense, but liberal theory in the sense that it says keep government off our back and protect individual rights, or in the Republican theory, which has something about general welfare and government has to act on behalf of society. And those are the two principal focuses, where I think that that's a mistake. I think in reality, we have a Constitution that's bound in two ways. The Declaration of Independence clearly speaks about inalienable rights, rights of individuals. The Preamble of the Constitution clearly speaks about general welfare. Now, that strikes me that it has to be a convergence of those two things, which almost everybody, for some reason, misses. In large part, they miss it not because of ignorance, because it really isn't ignorance with the astute people. It's because they don't think that these things can work out together, that they cannot be synthesized, whereas our constitutional documents say that, in fact, it's an article of faith that they must work out together, and that all three branches of government have to fulfill them. A pluralistic society like ours must respect dignity and use its power for the entire body politique. I think this is an objective ideal because it is set irrespective of contrary legislative, administrative, or judicial pronouncements. Thus, the ideal remains the same through the course of American history, and that runs through all the injustices that have been committed, including the major ones: slavery, Japanese internment, Indian removal, that this principle stays true, right? So to just kind of give a very maybe coarse contrast is if you think about something like the Nuremberg laws, Nazi Germany could have never created a society where it would retain its primary documents and it would be just. It was built on an injustice. And really, you could even say that with the Communist Party as well, to look at the other side, where there's a one-party rule that has only one concept, and you cannot break out into a pluralistic society of multiple ideas. The Declaration and the Constitution codify the fundamental social ethos of human equality and set the basic structure of governance. Discussions about the Constitution often put individuals at loggerheads with society. And I think that human productivity can best flourish in a society of equals where talents can be brought to bear in the betterment of self and other members of the community. Now, what's the relevance of that, right? Because it kind of sounds too philosophical. I feel like I got to explain it. Well, the relevance of it is quite simple. That typically it's thought, if I get something and my group gets something, the Democrats, the Republicans, the this race, the that race, the whoever you've got, that's going to be real good for us, and that's what we want. We want that's good, right? But ultimately, I think that amounts to something ill, and in fact, sometimes very, very evil. So that the white slaveholders thought that they were benefiting themselves and they were having a better life, right? They didn't have to clean up. They didn't have to cook. They could exploit this help. And yes, the help was worse off, but there were numbers that were smaller. But what wound up happening because of this thought? You know, us here, and they get a small piece of the pie, you get a greater happiness of us, and therefore things are better off, and that's a good way of society. What happens? You get a civil war. That's what you get, right? Because the way to think of it is not that there is us and there is them, but rather there's just us. And therefore, where one is hurt, the entire society is hurt because you get 100%. And so if you give harm to the one, you get a diminution of happiness in its entirety. And so it's just us. That's what we've got is us. And beyond us, as a people, as the United States citizens, is we have the wealth of the human community. And I believe that that's what Jefferson and the Founding Fathers, John Adams and George Washington, Madison and all of them, the way that they envisioned it was that they would create a society of human rights for the world. Now, they themselves were hypocrites, no doubt. Slave owners, not only slave owners, but in their treatment of Haiti. When Haiti sought independence because it was a black republic, they would not respect it as an equal sovereign. But the ideal was there, and the ideal stuck, and the ideal was one that allowed then the Reconstruction era and radical Republicans of the 1860s to speak in terms of fundamental values that existed in the Declaration from the beginning were not followed. Truth be told, few academics and even fewer courts rely on the Declaration of Independence and Preamble of the Constitution to establish firm ethical commitments of government. Unfortunately, nearly all constitutional scholars exclude them from discussions about how to interpret the Constitution, Bill of Rights, and other constitutional amendments. that's true of the preamble. I see, because I'm speaking plural and I use the pronouns, so I want to make sure it's not just the Declaration they exclude, but the preamble itself, which the Supreme Court has consistently said is not substantive. It's a bit like saying the Equal Protection Clause is not substantive. It's never been used before. And in fact, that is what was said at the early part of the 20th century until the court turned all of that around in Brown versus Board of Education and made the Equal Protection Clause of such high significance to contemporary times. So too, the Declaration of Independence and the preamble at this point are almost ignored, unfortunately. But they are key to the deliberative popular dialogue about our representative government. Together, they describe the purpose of government, the sovereign role of the people, the ideals of the United States, and political representation. They render certain motives for laws, that is, say, prejudice, hatred, bigotry, chauvinism, viewpoint discrimination, and so on, suppression, censorship, to be illegitimate. The key point is that they are not illegitimate solely because of those amendments, which often are so obscure. You take the First Amendment, right, to free speech. Well, what about laws about antitrust? That's a limitation on speech. What about trademark law? What about securities transaction laws? All limitations on speech. Aren't they free speech? It's absolute, isn't it? It shouldn't be. No, because we have certain principles about the betterment of society that trusts and violations of securities laws, they protect, and therefore it's not absolute. So that there's something more core, more fundamental, more at the base of our constitutional ethos that is even beyond, even more fundamental, even more bedrock than those constitutional amendments themselves. In a society of free and equal citizens, everyone has his or her own priorities, and therefore the preamble and the Declaration direct that holding the reins of government must seek the general welfare, not any individual, not any group, but the general welfare. The United States Constitution, like constitutions throughout the world, establishes a system of governance with structures, procedures, and substantive norms. Its terms are broad enough to facilitate legal development without having to regularly ratify new versions that meet changing demands of modernity. The United States Constitution and Declaration are ancient documents. Indeed, the national Constitution is the oldest in the world. Their clauses were composed at a time when the art of constitution making and popular sovereignty were little understood. Inevitably, they are chock full of ambiguities. What precisely does the Due Process Clause mean? And what is the pursuit of happiness? How about how specifically should the government provide for the safety and happiness of the people? What are the privileges or immunities of American citizens? And are they different from the privileges and immunities? After all, those are different terms used in the 14th Amendment than in the original Constitution. And by the way, what acts are high crimes and misdemeanors? We just had that conversation here fairly recently. As you know, what constitutes a high crime and misdemeanor? And what is good behavior in office? Right? These are all ambiguous. These and a host of other questions do not have simple answers in the text of the Constitution. The Constitution's open-ended clauses and the Declaration's aspirational statements about human rights, representative governance, equal citizenship make them the best source for political debate and judicial decision-making. In the end, we are left with supreme legal authority that remains stable but requires regular rethinking, reinterpreting, and re-understanding within contemporary contexts. And this is not just a matter of theory. Enforceable mechanisms are essential to guarantee individual rights for the whole body of our government. However, procedural restraints on government are by themselves no guarantee without violation of rights. And I'll speak about that. I just want to give a kernel of it, but I'll speak about that in a little while. That procedures themselves are not enough to protect our rights. Substance and protection of rights, the pursuit of happiness, inalienable rights clause of the Declaration are also critical. While the whole constitutional system depends on aspirational ideals. The constitutional text must remain the source of authority, as opposed to Great Britain or Israel, where the Constitution is unwritten. And that's fine for them, right? But in our system, we have a written Constitution, so the text does matter. I've been speaking about aspirational ideals, so now I want to speak about the text. In addition to determining how the Constitution applies to specific circumstances, there is something more that needs to be done. Courts typically simply look at doctrine, they look at the text, or they look at what the courts have said in previous decisions. But I think even more important than that often are matters of culture, history, social conditions, and of course the specific context within which the dispute arose. Our history, the feminist movements, the first wave, second wave, and on to today, the Reconstruction history, Reaganomics, what have you. These all play into the way that we think about our Constitution. However, I think it's too limiting to base decisions only on the perspective of the Constitution. Contemporary values of equality, liberty, social welfare are very important to make this ancient document relevant to our cyber times. But a stable foundation must remain, one that permanently respects human dignity while recognizing the value of history and ethical advancement. This foundation, and I think that's a lot of what goes into, for example, in Obergefell, the new recent case that found that gay marriage is constitutional. If you read Justice Kennedy's opinion, he could have read marriage very narrowly. He could have said marriage has always been between a man and a woman, therefore that's marriage. But he didn't. He read it in these very broad terms. And Justice Scalia took him to task. He said, marriage has always been understood to only be about man and woman, and that's not only true in our country, it's true throughout the world. But Justice Kennedy had a deeper, a broader vision, in which he said marriage was about something about not only giving dignity to the couple, but dignity to their children as well. That is an advancement in ethical thinking. It takes the core, it takes the original document, but it takes a step beyond certainly what the framers of the 14th Amendment could have thought. While statutes can be changed to reflect political preferences that emerge with each election, a written constitution sets expectations that transcend the existing debates between political parties and their leaders. The written constitution only sets a skeletal structure for efficient administration and the protection of the people's will to enjoy their rights on an equal basis without arbitrary restriction. Constitutional provisions like the unenumerated rights clause of the Ninth Amendment establish that an underlying ethos permeates the written text. While it stabilizes legal institutions, the Constitution's wording is too much to lend one specific answer. And that's why we debate, and that's why we have the First Amendment, and that's why deliberation and dialogue are so important to us as a people. The Supreme Court actually used the provisions of things like the Equal Protection Clause, believe it or not, and used the Declaration of Independence to protect inequality. And this is just to stress the importance of aspiration and principle. So let me tell you what I mean. In Plessy v. Ferguson, a case that upheld segregation on railroad lines, the United States Supreme Court said that the Equal Protection Clause meant that separate but equal was all that was necessary. And if you look at the text of the Equal Protection Clause, there's nothing that says anything other. You have to go beyond it to look at something else. Look at what? Well, you could look at contemporary principles of the day, and those principles were there, I believe. They had been planted by the Reconstruction and by the United States founding as well. But on a deeper level, they also come from the Declaration of Independence, which is why, if you look at the debates on the 14th Amendment, on the Equal Protection Clause, they're chock full of references to the Declaration of Independence, something that's almost non-existent amongst today's congressmen. And based on these things, we get the Warren Court with Chief Justice Earl Warren saying in Brown versus Board of Education that of course it couldn't have possibly meant separate but equal because that would harm the dignity of individuals. And in Brown versus Board of Education, recapturing what the idea of equality was that we would all be integrated, that we would all be merged in the synthetic general welfare. So that this misinterpretation of the Equal Protection Clause was based on a wrong textual reading, one that was not adequately principled enough. When the ideals of the Declaration were joined with moral principles, that was understood. Well, what about what I said about slavery? Well, Chief Justice Taney said in Dred Scott that the Declaration of Independence must only apply to white men. Why only to white men? Well, because they're the ones who wrote the Declaration of Independence, right? Of course, he had forgotten that the first to fight on the Boston Commons was a black man. But beyond that, the Declaration of Independence speaks about inalienable rights. It speaks about the pursuit of happiness. And it does not anywhere mention anything about race. And so that this ideal could be something that could be born in the hearts of abolitionists, in the hearts of slaves, in the hearts of free blacks, and could embolden them and could make them patriotic. And Chief Justice Robert Taney made a mistake that was not only a mistake later at some time, but based on the principles on which the country was built, was absolutely wrong. The constitutional rights that I speak about and the ideals in constitutional ethos demonstrate a stable principle of accountability that is needed for maintaining constitutional norms to deal with institutional, cultural, and historical changes. Constitutional theory must accurately describe our country's aspirations, criticize failures, clarify goals, and provide trajectories for social improvements. As I indicated earlier, the principle comes from the Declaration of Independence and the Preamble and has gone into all of these different amendments. The founding document's statements on government are general enough to make broad ideals binding on government in all official actions. Because this ethos is constitutional, it is obligatory on the president, on the executive, on the legislature, and on the judiciary. And again, while I want to say something that seems like almost a truism, courts almost never use the Declaration, and it's scarcely used, scarcely mentioned. Chief Justice Roberts recently used it in a bankruptcy case in passing to say the judiciary has to be independent. Why? Well, because King George III didn't allow the judiciary to be independent, and it's one of the paragraphs in the Constitution, right? So we can use it, but there's lots more. There's the right to petition in the Declaration. There's even the prohibition against quartering of soldiers, which goes into the Third Amendment later on. And the Preamble and the Declaration are at the roots of this ethos. And what I mean by constitutional ethos, because I imagine that probably comes up in your mind. What I mean by that is a pithy statement. I was taught by a philosopher many years ago that in order to have an idea, it has to be short. To be influential, it has to be short, it has to be understandable, and it has to be memorable. So this is the one that I come up with in the book that I try to prove. The underlying purpose of government is secure equal rights for the common good. And it's just that simple. And everything else stems from it. Provide equal justice for individuals for the common good. It's a simple statement, but it's the overall expectations that people have to be treated justly. Its value is both theoretical and to apply to specific actions and for practical applications. Structural portions of the Constitution, those granting powers, as well as assigning spheres of responsibility and establishing methods for deciding conflicts, all serve this normative goal. The state's sovereign authority derives from the will of the people, whose vital interests public officials are charged to safeguard. We see, unfortunately, too much of partisanship these days, of people trying to serve their respective political party rather than trying to serve the American people as a whole. My formulation takes into account the intrinsic value of each individual, but also the need for formal assessments of how law impacts the relevant communities. the theory will encounter, obviously, will encounter resistance. And I want to look at some of these, the ways that these might come about, kind of skipping ahead in the interest of time. So let me, first of all, before I move on to other theories, which I think are important to contrast and compare to the one that I've set out, let me just sum up first, if you don't mind, what I've been talking about. This book elaborates a foundational theory of United States representative democracy. My principal focuses on constitutional government, unlike most studies of constitutional theories, which tend to focus only on adjudication. Right? Almost all of our interpretation of the Constitution really comes from the courts. Ever since Marbury v. Madison in the early portion of the 19th century, when Chief Justice Marshall said, we say what the Constitution is, that's the way it's been interpreted. And I think that the preservation, and it's fascinating because the court uses the Declaration of the Preamble so little, it's left room for the people to be able to voice their ideals to their representatives, not to act on their own, because we are still a representative democracy, not a supermajoritarianism, which might often spring into a tyranny. My principal focuses on constitutional government. The statement of national purpose must be general enough to enable government to advance policies and safeguard individual rights and to exercise authority, and the people must benefit from the stable government. So what are some of the theories that are the most common that are opposed to this way of thought? One is, and perhaps the most obvious, the one that I've mentioned before, is textualism, right? And it simply says we take the text of the Constitution, it's binding, and the text there's no other rights beyond the text. All that exists are laws that either are embodied in statutes or specifically stated in the Constitution. And to that I say again that there's just too much ambiguity, too much uncertainty. There's always been interpretation. Even something as core as what I just mentioned, which is Marbury v. Madison, which is a case that said the United States Supreme Court is the final arbiter, final decider of what the Constitution means, or that the United States Supreme Court can even examine whether or not the legislature, the Congress, or administrative bodies under the executive branch have acted in violation of the Constitution. Even that's not there. Basic thing. I mean, you don't even have in there that the government can make paper money. It was a whole long debate in the end of the 19th century. So that the textualist approach, I think, is far too narrow. And in fact, it often serves as a form of modesty, a false type of modesty. Oh, I'm giving you my opinion on the text. I'm not giving you my own opinion. My opinion on the text is based on the text. It's nothing more than the text. But really, when you look at it, there's often politics involved, personal interpretation, and subjectivity. Another method that's used, and this one is much less in the public eye as much as it's extremely, extremely influential amongst political scientists, legal historians. It's something that hopefully many judges would be well versed on, and that's something called structuralism. This says that the function, certainly at least of the courts, is not to protect individual rights per se, unless they're specifically listed, but the structure of the Constitution. And this structure is one that is, for example, is one of representative democracy. And so if you don't like an opinion, Herbert Wechsler, for example, a very, very famous scholar, Harvard professor, said in the 1950s after Brown versus Board of Education came out, and Judge Friendly, another major leading light circuit court judge, said Brown versus Board of Education was wrongly decided. Why? Well, it's just not in the text. They've gone beyond it. It's just outside. It should be decided based on structure. So structure has to do things like representative democracy. So maybe you could have this statement against segregation in schools, but it has to say that, well, for our democracy to function better, there has to be desegregation, something along those lines, where I want to say, no, there's a fundamental right of dignity involved. And Chief Justice Warren got it right, that the problem with black kids sitting in separate classrooms than white kids, it goes beyond just our whole system, but their individual rights and the fact that they're looked down upon, that they're thought that they cannot function well enough in a classroom where there are people of other races. And this theory of structuralism often says in one of its leading acolytes, a brilliant man named Philip Bobbitt, a professor who's at the University of Texas and Columbia. He has 2 appointments. He says, well, what we really have is just a grammar. It's not that it's not principle. There's a grammar. So if you use the right grammar, or if you use the right semantics, then you speak correctly about the Constitution. So he says the right grammar is the Constitution can be spoken of either as text, as history, as structure, as doctrine, which is court-created law, as what is accepted as social ethics, which is not to say there's any core ethic, but just whatever of the day is considered to be the ethic, or as prudence, what's pragmatically good. And I think what's missing in Bobbitt's interpretation is anything about ideology and ideology, right? The reason why the Declaration of Independence is read throughout the country on the 4th of July is because we think that there's some sort of an ideal in it. It's not just, let's use the language, and if the pursuit of happiness will simply mean what Chief Justice Roger Taney said, just towards white men, well, I mean, he's used the language after all, right? That to me seems a very, very problematic interpretation, that there has to be something that the country is committed to beyond just, well, here's the way we use the rhetoric of this. And the government's requirement to secure safety and happiness is not just a matter of some politician standing up and using the right words so that we all feel good and can, the polls say to him, you can get the votes by using those words, but rather that this person seeks the actual safety and happiness of the people. The Declaration and the Constitution codified a political ethos predicated on the people's decision to enter a political compact for creating representative government with the power to pass rules to maintain life, liberty, and the pursuit of happiness. Another interpretation, that's another leading interpretation, and this is one, again, these are things that I discuss in the book, but they would be easily recognizable to constitutional scholars, is one that was put forward by Robert Dworkin, in which he says there is a correct answer to any question, and the judges, at least not real judges, but a hypothetical judge, Hercules, he's going to be able to say what's the correct answer to any different question. Well, I think that puts far too much credence in the judiciary. I think it's almost naive to think that there's going to be a correct answer. I think the function of our government is to debate, which is why Congress debates, right? And that's a great thing. We have different points of view, and you convince me, which was less partisanship, but that's the function of it. I also think that what Dworkin is missing is he doesn't say what the source of that ethos is. And there, I think we've got to be anchored in our formative documents. The final 2 theories, I think, will be easily recognizable to anybody who reads newspapers on a regular basis, and those are originalism and living constitutionalism. The originalist theory is that we have to interpret the Constitution precisely the way that the framers wanted it to be, and let me stick with that before going on to living constitutionalism. This, as it was originally formulated, has combusted. The original major thinker of it was Judge Bork, who was up for Supreme Court justice, of course, was never put on the court. And the early interpretations of this by others, not only just Judge Bork, were that what we have to look at is the original intent of the framers. There's almost no originalist that believes this. The legal originalists, currently Stephen Calabresi and Randy Barnett and others, they certainly don't believe this. The reason is, first of all, it was impossible to tell who were these people, the original framers? Are they the people in the state ratifying conventions? Well, we don't have a clear record of that. We don't have enough to tell what that is. And they were the ones who ratified the Constitution, after all. Were they the people who were debating the clauses of the Constitution? Well, not everybody spoke in Congress who debated it. There were only just a few leading people. And what were their original intents anyway? I mean, they said one thing in Congress, just like congressmen nowadays, right? They say something in Congress, and they have other things that are their concerns. They're not going to say all of their concerns in Congress. Some people will speak less, some people will speak more. So the current leading originalists, the real influential people currently, the people who are influential on Justice Thomas and were influential on Justice Scalia, and people who continue to be tremendously influential, are people who believe in the original meaning, not original intent, original meaning, or the original reasonable interpretation. What does that mean? They say, look, okay, it's true that people like Randy Bennett, it's true. We cannot tell what was the original intent. Who can tell what the intent is? But we can tell what the original meaning is. How? Well, we can look at dictionaries. We can see what the words they use in the Constitution. We'll look at the dictionaries. We could look at what would the ordinary person mean when he said free speech or something of that type. Due process, the ones that I mentioned before. Well, that's very problematic because dictionaries say different things, newspapers say different things, and you're not really going to get at what a common person thinks. It just, people use words differently. Think about just basic terms we use on a daily basis. Love and friendship. Are you going to really get at the basic meaning that we're all going to agree on? Love and friendship? We still haven't figured it out, and Aristotle talked about it a couple of thousand years ago, and we're still trying to figure out those ideas, much less privacy, which is so hot now in the cyber world. Now, living constitutionalism is the opposite way of thinking, and that is one that Justice Brennan, for example, espoused. This says that the Constitution is a living document, that it has to be, it's an arrogance to think that to use originalism, as Justice Brennan said, and that the Constitution has to be thought of as a living, evolving document in the development of ethos. I think the problem with that theory is it doesn't tether, it doesn't anchor it to anything. How would we know whether the current ethics of the day is the one that's our constitutional ethics? And it has the opposite problem of originalism, I think. So I think where we go is we have this core constitutional foundation that's based on our preamble, it's based on our Declaration of Independence, and that evolves from these foundational documents, takes into account our contemporary ethics, our culture, the specifics of the problem of the day, but that isn't just floating out there by contemporary standards. Now, let me tell you how this applies to some recent issues, and perhaps now I will go into something that is the most controversial part of the presentation because when we get to contemporary politics, the issue gets much more strained. How would I think that this theory can be applied? One thing is to campaign finance reform. The court in cases is very, very famous, appears throughout newspapers around the United States, Citizens United, began unraveling some legal barriers against political corruption when it found unconstitutional a key provision of the bipartisan, and I stress bipartisan, Campaign Reform Act. This is the McCain-Feingold Act. The court decided that for-profit corporations have the same political free speech rights as natural persons, and therefore the federal law subjecting corporations to special restrictions on their efforts to influence political campaigns violated this entity, Citizens United's First Amendment right to fund campaign speech. Now, the case may have even been decided correctly, because Citizens United was trying to get a movie that was antagonistic to Hillary Clinton when she was running years ago, not this campaign, out there to the public. Maybe they should have been allowed to do that, because that does seem like a political issue. The more difficult problem, in my opinion, is the actual decision and the way that this thing came out. So maybe the judgment was correct. I'm not even going to quibble about that. I'm glad to do it in a question and answer setting. But the decision that corporations have the same free speech rights, that seems to me the real problem. Lost in the court's seemingly hard rejection of campaign finance laws targeting corporation is any meaningful consideration about the contrasting role between artificial for-profit persons, that is businesses, and natural persons, that is, say, ordinary citizens, or organizations voicing collective views of natural persons. It's one thing to think about maybe Citizens United was an association of citizens, or of the NAACP, or the NRA, or the ACLU, and quite a different thing to think about a for-profit corporation. The pursuit of happiness and the Inalienable Rights Clause of the Declaration of Independence and the General Welfare Clause of the Preamble provide natural people to participate politically in their self-advancement and social well-being. For-profit corporations, on the other hand, are not formed to advance inalienable equal rights, but commercial interests of their investments. Hence, in the free speech realm, commercial speech is not treated identically with political speech, but receives low-level judicial scrutiny because increasing profit margins are not the same thing as advancing representative government. By definition, corporations and their officers always have a profit-making obligation. That's their fiduciary duty. And their expressions for commercials go to that. So I'm being told that I'm running out of time. So let me then rush through a couple more examples in just a minute or so and then open it up to questions. Another issue, I believe, is judicial supremacy. As I said to you, the Supreme Court takes it upon itself to be the sole interpreter of the Constitution and therefore has struck down United States laws, congressional actions over and over again, bipartisan laws. For example, the Violence Against Women's Act, which was an incredible bipartisan act, or now limiting the Voting Rights Act of '65. These are bipartisan efforts, and yet the court, time and again, says that we are supreme and we can interpret. But we, the people, seem to be sovereign, and that is through our representatives. So I would say that where the court is protecting rights, Congress cannot violate those. But where it is limiting rights, restricting Congress's ability to protect rights, there should be some supermajority, such as a veto power. 3/4 majority, 2/3 majority, make it what you will. There's nothing in the Constitution that bars it, to reconsider what the court has done. And I can speak about some other things. Maybe we'll do it in question and answer. But let me stop now. And if you have any questions, if you wouldn't mind, please going to the microphone. Thank you so much for your time.
Thank you so much for your talk. I've been to many lectures in many places about political theory. I've never heard such a succinct, inspirational review of who and what we are as Americans. Question. Of course, in today's political climate, we're far away from these ideals and governing principles that you speak of. How often in U.S. history have we been this far away? I contrast that with my own youth years, which are far in the past now for me, of the 1960s, when there was fervor for these principles. It was in the air. And I would have never predicted that 50 years in the future, here we are. But how often have we been away from what you speak of, not only in today's world, but in U.S. history, if you have some sketch of that.
Yes, thank you so much for that question.
Thank you.
The unfortunate thing is that American history has had times when we've deviated very significantly from our aspirational ideals. I've spoken about specifics, so let me speak about times, because this is what the gentleman asked for. In Jacksonian America, the treatment of Native Americans and the decision to take them off of the land was certainly a horrible deviation. We still think of Jackson as being this tremendous hero. He's on our $20 bill. But he was, during his time, I must say, he had a nickname. His nickname was King Andrew. But, we've forgotten that now. But if you look at the contemporary newspapers of the day, they would say that often. And so I think, the times of Indian removal were certainly that. I think that another time was when Pierce was president, Buchanan was president, and Millard Fillmore as well, during the 1850s, leading into the Civil War, when there was a rolling over to Southern interests in slavery. Was another time when we were very, very far from the ideals and the principles for which this nation stands. But it goes much deeper. I mean, the nation's treatment of women is how 50% of the population, more than 50% of the population, how couldn't have been understood that pursuit of happiness and could have meant half the population. Well, I mean, that's not to mention blacks, right, and Native Americans and those other cultures that were not respected, is almost unfathomable. Now, you might say, well, look, we can't understand that. It does say in the Constitution, all men are created equal. You haven't even said that once, have you, Tsesis? Well, that's true, but the way that the feminists understood it during the beginning of the 1830s with the Grimke sisters and Susan B. Anthony's, Elizabeth Cady Stanton, Lucy Stone, and the like, was that men means humans. Well, you might say, well, they're just interpreting, but not really, because the United States Constitution does not use male, M-A-L-E, until the 14th Amendment, the second section. And everybody understood male meant only males. And people understood men to mean, humans. Now, you might quibble with the word. You might say that's not a good word. It's too ambiguous, or maybe it is. But, there were other times. Another time I might say, just very quickly, is when Thomas Jefferson, who of course is the author of the Declaration, who was deeply committed to anti-slavery. By 1820, by the Compromise of 1820, which separated slave states regions from non-slave regions, he had really given in to saying, there's nothing we can do about slavery, even though in his youth, in the 1770s, it was a different story. So unfortunately, I would want to say, everything's flowery and great in much of the American history, but I believe it's these ideals that have carried us to where we are now, which is, we're still on the horizon. Yes.
I've got a question about the write-up that introduces you, and it specifically says, expert witness for the Canadian Department of Justice. Could you elaborate on how that applies to constitutional law and how the constitutional law, I guess, is interpreted by other countries, perhaps Canada or others that have taken parts of it and applied it to their own law?
Yeah, thank you so much. I was a witness to the Canadian Department of Justice on the issue of hate speech. So it's not particularly important here, but I'll be glad to answer because you asked. United States laws on hate speech are much more protective. What happened recently with Ku Klux Klan rally is an example of what I believe is a problem with the way that our First Amendment is interpreted, whereas Canada and other countries believe that dignity and democracy and pluralism are sometimes trump free speech. And I believe that as well because, the Nazis showed the power of speech and those who supported Indian removal showed it as well. That the Hutus did as well in Rwanda. in calling the Tutsis and Yenzi cockroaches. So the Canadian government had me come out and testify as an expert. And it's actually things that were mentioned in my first book. Mr. Ferriero mentioned that book. It's called Destructive Messages, How Hate Speech Paves the Way for Harmful Social Movements. I have another one out, if you're interested in this subject, on terrorist speech, how terrorist speech can be limited without violating the First Amendment. So I continue to work in this area. But I think more pertinent to this particular talk is the second part of your question, and that is how it compares to other countries. What's interesting is that our declaration with its statement of rights and its preamble is very unusual. Most declarations of independence, especially of that time, Latin American declarations of independence, for example, did not have any statements of rights. They simply said why it is that they deserve their independence from the colonial power. So we have this unique, it's not entirely unique in today's standards. There are now declarations of independence that in fact do have human rights values, but the United States Declaration of Independence, Haiti was another one that had a statement of rights, but almost nothing had them. Not Venezuela, not Colombia, and other countries. Also, I guess I think beyond that, and this is something that I need to bring more proof to, is that I think our declaration really inspires people around the world. So I hope that that answers your question. Maybe if not, you can follow up.
Another question that you talked about interpretation at such time and dictionary definitions of words used. We know of the Constitution trying to be amended and continuing to be amended. Was there any issues with, I guess, other than equal rights for man, that the Declaration of Independence being a controversy as far as how it was written and language that's in that as it is today? I'm just curious if there were points of interpretation there or things that someone would say we need to amend this Declaration of Independence in the current time or a future time.
So you ask really profound questions. One is, well, in fact, I feel like I'm going to forget it by, let me see, let me just write a couple of words here. So three things. One is that the amendment process is tremendously difficult in the United States. Not so around the world, but because we need such a supermajority. And so I think principle and the reason why we've been able to achieve such great strides is because of our ability to amend the Constitution's meaning without truly amending through its formal processes. As to the controversy was to a clause that Thomas Jefferson sought to include, which was a statement against King George for allowing the slave trade. Mr. Ferry, of course, knows this one, for allowing the slave trade to exist in the colonies. That was the controversial statement. That was X'd out. It was not a statement against slavery. It was a statement against the slave trade. That's a very unfortunate thing that was X'd out, because I think that Jefferson wrote it in originally, but to placate, it's generally thought to be the South, but in reality I think that the most convincing statements are that there were only really a couple of states in the South. I believe it was North Carolina and Georgia, as I remember from my memory, were the only ones who would not have signed this Declaration of Independence had that paragraph been in. Finally, a much more controversial point is here, who knows, maybe I just stand alone, I'm not sure. I don't think the Declaration is amendable. There's no clause, there's no provision in it. Like in our Constitution, it says how to amend it. But there's no clause like that, there's no paragraph like that. So what does that mean? That means that the only way you can amend the Constitution is by a revolution. Now what would that mean? Presumably it would mean overturning an order in which a government pursues happiness, seeks the safety and welfare of its people, and protects inalienable rights. I mean, that would be catastrophic, it seems to me, amending that sort of ideal.
given today's political climate, one major deficit is in the politicalization of congressional districts. It virtually renders the representatives of Congress impossible to have thoughtful debate. Do you have any how would you go about fixing today's world? Your articulation of who and what we are, I rarely hear that. I would hear it, I'm reminded of some very famous speeches, but other than that, we don't hear it. How would you go about fixing things? I mean, that's maybe over.
The Supreme Court is actually considering that in this term, right? I would hope that they will find that gerrymandering.
Oh, that was the word I was looking for.
Well,
Sorry to interrupt
made it
you.
clear. No, I understood, of course. The gerrymandering, when it's done purely for political reasons, is unconstitutional. I mean, what the test will be, I'm not an expert in it, and the Supreme Court has struggled with it, and it has not been able to come up with a test. I hope that this time it will. But I agree with you. I think that it's critical for people to represent everybody, which is, that people, people seek control and they seek office. I mean, that's just the reality of it. And I hope the court does enunciate something that's more along the lines of our equal representative democracy, as opposed to something that really just favors parties. Thank you so much for coming. I'm deeply grateful to you for spending time with me. Thank you.